पापा ने पानी डालकर मम्मी की आग बुझाई थी। वहां पर बहुत सारे लोग आ गए थे। जिस समय मम्मी ने अपने को आग लगाई उस समय पापा मेरे साथ थे।
बताइए, इसको आपने एग्जामिन ही नहीं करा है तो आई विटनेस है, खुद कह रही है, वो अपने डाइंग डिक्लेरेशन में लिखिए।
दिस इज सेकंड एप्लीकेशन फॉर सस्पेंशन ऑफ सेंटेंस। In this, my lord, the first was dismissed on
जाइएगा भाई,
para 3, my lord, of judgment.
एक मिनट रुक जाइएगा। एक ही का कन्विक्शन हुआ है क्या?
नहीं, my lord, four
मृत्यु हो गई थी,
persons were prosecuted, my lord.
दो का एक्विटल हो गया,
दो
एक
का
की मृत्यु हो गई,
दो का कन्विक्शन हुआ।
तो उसमें एक की मृत्यु हो गई।
हाँ, एक की मृत्यु हो गई।
आप
उससे
अकेले बचे।
हाँ, मदर इन लॉ है my lord, 70 years से अबव है और 7 साल से ज्यादा से जेल में है my lord.
जी जी जी।
In this, my lord, kindly consider two facts, my lord.
जी।
One is that, my lord, Dhani Prasad, who was the husband of deceased Ramvati, was injured in the incident, my lord.
जी। वो कौन है?
His-
धनी प्रसाद कौन है?
धानी प्रसाद डिसीज का हस्बैंड है, हमारा सन है।
वो तो बता रही था ही नहीं, मौके पर नहीं।
हाँ, जबकि वो इंजर्ड है, उसने सेव किया है। 100
बाद में आया कह रही है ये तो।
हाँ, इसमें
डाइंग डिक्लेरेशन पढ़िएगा, एग्जिबिट P11।
मैं जो कहूंगी सच कहूंगी।
तो हो गया। देवेंद्र घर में था, देवेंद्र क्या कह रहा है? देवेंद्र की गवाही।
देवेंद्र के 164 के स्टेटमेंट होते स्टेटमेंट हुए। उसने कहा कि मदर ने खुद को आग लगा दी, बट ही हैज नॉट बीन एग्जामिन्ड।
कहाँ है वो देवेंद्र का स्टेटमेंट?
स्टेटमेंट चार्जशीट के साथ ही है, मैं पढ़ दे रहा हूँ।
देवेंद्र तो इसका खुद का लड़का है।
हाँ, खुद का लड़का है।
खुद उसकी प्रेजेंस बता रही है घर में।
हाँ, और वो उसका स्टेटमेंट में पढ़ दे रहा हूँ।
उतनी तो बहस होनी थी टोटल
जी,
उतनी ही तो टोटल बहस होनी थी।
हाँ, उसको एग्जामिन नहीं किया कोर्ट ने।
अरे उसका स्टेटमेंट ही तो पढ़ना था आपको, और करना क्या था?
110
देवेंद्र कुमार। हाँ
जी।
चलिए।
मैं ग्राम बंधन का रहने वाला हूँ। मैं कक्षा 8 में पढ़ रहा हूँ। मैं बकरी में खड़ा था, मेरी मम्मी घर में थी। मेरी मम्मी ने घर का दरवाजा बंद कर खुद पर मिट्टी का तेल डालकर आग लगा ली थी। मम्मी अपने शरीर में क्यों आग लगाई थी इसकी जानकारी मुझे नहीं है। आग बुझाने के लिए मेरे पापा रसोई के पीछे दरवाजे से गए थे। पापा ने पानी डालकर मम्मी की आग बुझाई थी। वहां पर बहुत सारे लोग आ गए थे। जिस समय मम्मी ने अपने को आग लगाई उस समय पापा मेरे साथ थे। पापा ने मम्मी के साथ कुछ नहीं किया।
बताइए, इसको आपने एग्जामिन ही नहीं करा है तो आई विटनेस है, खुद कह रही है, वो अपने डाइंग डिक्लेरेशन में लिखिए। श्री डॉक्टर अनुवाद श्रीवास्तव, लंडन काउंसिल फॉर द अपीलेंट श्रीमती गोलवती बाई, full stop. It is submitted that this second application for suspension of sentence, first one was dismissed by a coordinate bench wide order dated 6/3/2024 without taking into consideration the statement of eyewitness Devendra Kumar Bhalavi, who has not been examined by the prosecution before the trial court, though his statements under section 164 within bracket 5 CRPC were recorded by Shri Arvind Singh Tekam, Judicial Magistrate, First Class, Lucknow. Full stop. Next. Thus, it is evident that prosecution deliberately omitting to cite Devendra after getting his statements recorded under section 164(5) as a witness is a major lapse. Full stop. The work of the prosecution, it is submitted that work of the prosecution is to bring out the truth and not to concoct the evidence. Full stop. And all these facts are taken into consideration and dying declaration exhibit P11 is read. पूरा एक्विटल का केस है
जी।
क्या हो गया भैया, बताइए ना। अरे बताइए ना।
एक एक्यूज तो मर ही गया सब।
एक ही तो बच्चा है,
फाइनल कर
इसको फाइनल ही कर देना, आपकी अनुमति है ना? जी जी।
3 जजमेंट है इस पे लॉर्डशिप।
वो भी ले लेंगे, फैक्ट्स को लिखा पूरा, फैक्ट्स में लिख लोगे, ऐसा लिखना अपील इज हर्ड फाइनली, ऊपर का जो लिखा है वो सब जोड़ लेना बीच में। अपीलेंट इज एग्रीव्ड ऑफ द जजमेंट डेटेड 4/8/2023 passed by learned second additional session judge Lucknow district Sivni in ST number 07/2019, whereby upon trial two of the accused persons, namely Shobharam and Vajanti, were acquitted by the trial court, whereas one of the accused, namely Sumat Lal Bhalvi, father-in-law of the deceased and husband of the present appellant, died. Therefore, trial court recorded conviction of Srimati Golbati by under section 302/34 IPC and has sentenced her to life imprisonment with fine of ₹5,000 with default stipulation of 3 months RI. Next where it is submitted that appellant is innocent. She has been falsely she has been wrongly convicted. Full stop. It is pointed out that prosecution, that pointed out that victim in her dying declaration as contained in Exhibit P11 stated that whatever will be said by her will be correct. Full stop. At the time of the incident, she was cooking her food. Full stop. At that time, her mother-in-law, father-in-law, husband, children, husband and one of the elder son, Devendra, were at home. Full stop. Thereafter, she stated that she was not being looked properly by her in-laws. Full stop. Her mother-in-law is Golwati and father-in-law is Sumat. Full stop. Her in-laws had poured kerosene oil and put her on fire, and then they had run away towards the fields. Full stop. Thereafter, she improvised her statement and said that when kerosene oil was poured, at that time her husband was not present. Full stop. Then she stated that she was brought to hospital by her husband and Jeth Tirath. Full stop. Then she stated that her Jeth Jethani, namely Jeth Shobha and Jethani Bejanti, were committing atrocities on her. Full stop. Next paragraph. Shri Shrivastava submits that Devendra, whose presence is admitted by the victim in his 164 within bracket 5 statements, वो मैंने ऊपर लिखा दिया था, correlate कर लो, जोड़ लीजिएगा यहाँ पर. Next, thus it is pointed out that it's a case of false implication. Full stop. Her husband actually sustained burn injuries while trying to douse off the fire. Full stop. It is further submitted that इसका पति examine हुआ है?
नहीं हुआ.
Her husband too has not been examined, though it is an admission that he had tried to douse the fire. Full stop. Another person, namely Omkar Kodapa,
और उनका कोड़ा बम.
Omkar Kodapa, who has been cited as prosecution witness, has not supported the prosecution case. PW कितना है Omkar Kodapa?
4.
Full stop. Omkar Kodapa, PW 4, has stated that नहीं भाई, ये थोड़ा आप जो बोल रहे थे वो हॉस्टाइल हो गया.
PW2 तीरथ है, ये भी बता रहा है कि इसने सुसाइड कर ली थी, ऐसा उसने
तीरथ ने बताया है.
PW2
हाँ, PW2 लिखिएगा, ये ओमकार भी गोड़ा पापा.
तीरथ
PW2
पैरा 2.
Tirath Singh stated that Rambati was upset and had poured kerosene on herself. Full stop. He had travelled along with Rambati in the ambulance to the hospital at Ghansor, from where she was referred to Jabalpur. Then he had accompanied Dani Prasad till village Kahani. Full stop. At village Kahani, mother-in-law of Dani Prasad and brother of Rambati had met, and they had travelled till Jabalpur in the ambulance. Full stop. He has stated that Rambati was residing properly in her in-laws' house, and there used to be occasional dispute between them. Full stop.
नंदलाल पैरा 3 है. PW3 पैरा 5.
Lal Kudopa in para 5.
जो कहत थे वो कर लिए।
Has stated that Ramvati stated in front of him that whatever she used to say, she has done it. Full stop. Thus, it is pointed out that it's a case of suicide which has been turned into that of homicidal death, and therefore the conviction of Golbati is contrary to the facts and facts which have come on record and the law as laid down in लाई दीजिएगा judgment दीजिएगा.
Para 19, my lord, when material witness is not examined, the whole prosecution evidence becomes doubtful. Para 19, my lord.
Places reliance on judgment of Supreme Court in Takhaji, Hiraji versus Thakur, Kuber Singh, Chaman Singh and others, AIR 2001 SC 2328, wherein in para 19, Honorable Supreme Court has held that within inverted commas, it is true that if a material witness, comma, which would unfold the genesis of the incident or an essential part of the prosecution case, comma, not convincingly brought to fore, FORE, otherwise, comma, or where there is a gap or infirmity in the prosecution case which could have been supplied or made good by examining a witness, which though available is not examined, comma, the prosecution case can be termed as suffering from a deficiency, and withholding of such material witness would oblige the court to draw an adverse inference against the prosecution by holding that if the witness would have been examined, it would not have supported the prosecution case. Full stop. On the other hand, if already overwhelming evidence is available and examination of other witnesses would only be a repetition or duplication of the evidence already adduced, comma, non-examination of such other witnesses may not be material. Full stop, inverted commas closed. नहीं, लेकिन यहाँ और अलग full stop. In the present case, as per the statement of the victim as contained in her dying declaration exhibit P11, she has initially shown presence of her husband, comma, accused in-laws, comma, and elder son Devendra, full stop. Prosecution did not deem it proper to either examine her husband or elder son Devendra, full stop. Therefore,
prosecution इसमें रिलायड नहीं करता वो ये इंडिकेट करेगी कुछ
नहीं ठीक है, लेकिन जब नहीं ये खुद जब बता रही है कि देवेंद्र था वहां पर बैठना, तब तो नहीं ठीक है, नहीं बुलाया, लेकिन बाहर तो प्रोसिक्यूशन पे डिस्चार्ज करने का भाई, अगर भाई देखिए जब खुद ये बोल रही है घर में कौन कौन था, बाकी विटनेसेस 5 विटनेसेस नहीं है घटना के, तो बेस्ट विटनेस उसको एग्जामिन नहीं कर सकते, नहीं कर पाते तो नहीं करना चाहिए, क्लोजर करना चाहिए था। हाँ, क्या लिखा? Elderson Devendra, who have been cited by the victim as the eyewitnesses and whose presence has been mentioned in her dying declaration exhibit P. Full stop. Thus, there is a major lapse on the part of the prosecution in not examining these 2 witnesses. Full stop. Dheeraj Singh is the person, PW2 is the person who has हाँ वो लिखा देंगे, वो फायदा, अभी तो इनका आर्ग्यूमेंट लिखा है, क्या लिखा? Who had taken the injured to the hospital. He has categorically stated that Rambati was upset and she had stated that and he had heard that she has stated he had heard that she had poured kerosene on herself. Full stop. PW3 Nandalal Kudopa has also stated that Ramvati is daughter of his brother Omkar and his niece. Full stop. He has admitted in para 5. He has stated in para 5 that when Ramvati was brought in ambulance to village Kahani, then he had met Ramvati. Full stop. He had asked Ramvati as to what had happened. Then Ramvati said that whatever she used to say, she did it. Full stop. It has also come on record that in cross-examination, this witness admitted that Ramvati, before her death, had not given any statements against her in-laws to the police or to the court. He admitted that he had not lodged any complaint in relation to Ramvati at any place. Full stop. He also admitted that after 6 months of marriage, in-laws of Ramvati had separated Ramvati and her husband Dani. Full stop. He also admitted that in an attempt to save Ramvati, Dani too had sustained burn injuries. Full stop. He had sustained burn injuries on both his hands, face and chest. Full stop. Thus, it is submitted that it's a case of acquittal, and in fact, prosecution was obliged to file a closure report, but in a malified and mischievous manner, charge sheet was filed and conviction has been recorded without appreciating the facts on record. Next pair. Shri Nitin Gupta, learned public prosecutor, in his turn supports impugned judgment of conviction and submits that one application for suspension of sentence was already dismissed on merits on 6/3/2024. Therefore, no by a coordinate bench, and therefore no further indulgence be shown. Next, after hearing learned counsel for the parties and going through the record, it is evident that the statement of Devendra Bhalavi, son of victim Ramvati, is available on record as were recorded by the learned magistrate under section 164 within bracket 5 CRPC. Next pair. Devendra has been cited as a person who was present in the house when the incident took place. Full stop. This is evident from the statements of dying declaration of the deceased Ramvati as are contained in Exhibit P11. Full stop. When evidence of PW if evidence of victim is examined, then on the one hand, she has tried to show presence of her husband, and then later on, with a view to give clean chit, has tried to say that he was not present at the place of the incident. He came later on and had brought her to the hospital. Full stop. Neither the husband nor the son, Devendra, have been examined by the prosecution. Full stop. Two of the prosecution witnesses, namely Tirath PW2 and PW3, have stated that Ramvati had put herself on fire. Full stop. PW3 has gone to the extent of saying PW3 Nandalal Udopa, who is uncle of the deceased, has gone to the gone to the extent of admitting in cross-examination that husband of Ramvati and Ramvati were staying separately from their in-laws after 6 months of their marriage. Full stop. Thus, when material eyewitness Devendra in his 164(5) statement said that his mother had poured kerosene on herself and burnt herself when father had entered from the rear gate of the kitchen to douse the fire, we have no iota of doubt that prosecution has tried to suppress the correct and material facts from the court, and learned trial court was ignorant enough to not to pay heed to the important piece of evidence that when in the dying declaration itself presence of Devendra is cited and prosecution failed to examine the so-called eyewitness as cited in the dying declaration, then in the light of the judgment of Supreme Court in Thakaji, Hiraji, Supra, the inference, an adverse inference is required to be drawn against the prosecution for not proving their case beyond reasonable doubt. Therefore, in the light of this aforesaid judgment, नाम पूरा डाल लीजिएगा इतना इतना, we are of the opinion that since prosecution has failed to discharge its burden, appellant is liable to be acquitted, and accordingly, finding of conviction is set aside. Appellant is acquitted of the charges. If not required, be released forthwith. Record be sent back. Property be disposed of in terms of the orders of the trial.
Presently, appellant 70 years old lady.
हाँ उसमें डाल देना ऊपर 70 साल की लेडी.
फाइन डिपॉजिट कर दिया है.
बहुत अच्छा किया वो.
जी.
वापस करने की एप्लीकेशन लगा लीजिएगा. आप में अगर हिम्मत है तो.
जी.
तो ऑटोमेटिक मिलेगा उसमें कोई दिखाने की जरूरत नहीं.